Major breaking news. The United States Court of Appeals for the 7th Circuit out of the city of Chicago has just found that it is perfectly fine to disarm and prohibit the possession of firearms from illegal aliens. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, we have a major case here. It went the way I predicted, notwithstanding other courts that have disagreed with me, but no major court will disagree with me on this one, and that is, there is no doubt that under the Second Amendment, illegal aliens, those people that are not American citizens and are here in our country illegally, there is no way, no how, that these individuals will be deemed to have Second Amendment rights entitling them to possess, to keep, and bear firearms. Period. Full stop. Further proof of my conclusion is the decision by the United States Court of Appeals for the 7th Circuit out of Chicago in a 3-0 decision. They concluded that indeed an illegal alien who was caught with a firearm in 2020, I believe, is when he was first found with a gun, shooting it, they concluded that he could not assert his right to keep and bear arms under the Second Amendment as a defense to his indictment under federal gun control law, Title 18, U.S.C. 922 G5, that deals with illegal aliens are not allowed to possess firearms in America. Period. Full stop. So that's what this case was about. And this court essentially found two things, one a little bit softer, one a little bit more firmer. As you know, under the methodology set forth in Heller and then Bruin, we start with the text of the Second Amendment. To the extent that the text of the Second Amendment is implicated by the case, the burden shifts to the government. The presumption is that the gun control law is unconstitutional, unless the government can show there's a historical tradition of firearms regulation consistent with and analogous to the modern-day gun control law. In other words, the history has to line up with the modern-day gun control law, both as to why the historical law was enacted, why the modern-day gun control law was enacted, as well as the approximately how they were implemented. So here you have a situation where an illegal alien, Mr. Carballo Flores, I may have mispronounced his name, but Mr. Flores will go with, in the case of United States versus Flores, in this case, the 7th Circuit said that indeed the Second Amendment does not protect the right to keep and bear arms of illegal aliens in America. Here's what the court had to say, summarizing the facts of this case and the issues presented. Chicago police arrested Mr. Flores after he repeatedly fired his pistol in a city street. A grand jury later indicted him for possessing a firearm as an illegal alien in violation of 18 U.S.C. 922 G5A. We must decide whether that federal law comports with the Second Amendment. And of course, we know what the 7th Circuit did. They laid out basically the law of the Second Amendment right here. The Second Amendment secures the right of the people to keep and bear arms. In Heller, the Supreme Court held that the right belongs to individuals irrespective of their ties to the military, and the court has since confirmed that the people's freedom to carry arms is not a second-class right, citing to McDonald. It ranks instead among the fundamental rights necessary to our system of ordered liberty. That's exactly right. And then the 7th Circuit goes on to basically say, hey, and don't forget, this is the standard for assessing whether or not a modern-day gun control law is consistent with and comports with the right to keep and bear arms and the Second Amendment. Like the constitutional right itself, the government's power to regulate has its limits. The Supreme Court in Bruin set out the now familiar test for evaluating whether a firearm restriction exceeds those limits. To begin, a court must interpret the Second Amendment's plain text. When the text covers an individual and his conduct, the Constitution presumptively offers protection. The government may, however, rebut that presumption by persuading the court that the regulatory burden is consistent with the nation's historical tradition of firearms regulation. This requires, of course, reasoning by analogy. A modern regulation with relevantly similar historical counterparts will survive Second Amendment scrutiny. So after setting out the standard, of course, they turn to the text. Now, the text of the Second Amendment in relevant part says, the right of the people to keep and bear arms shall not be infringed. And this is where it starts to get interesting. Now, in my view, if I were on the Supreme Court, and I think this U.S. Supreme Court would agree with me, that illegal aliens are simply not part of the people. If you look at the definition of the people in the Supreme Court's decision in 2008 in the DC versus Heller case, they specifically say that the people, definitionally in the Second Amendment, are those people that are associated with our national community. And illegal aliens, as I see it, although the court has never said so, I'm pretty sure that the court will say that illegal aliens are simply not part of our national community for various reasons. Here's what the court here, in this case of Flores, had to say. This is the Seventh Circuit, writing now. We begin with the Second Amendment's text. The parties argue about whether Mr. Flores, an illegal alien, is among the people that the amendment protects. According to the government, he is not, because that term covers only American citizens. Well, the U.S. Supreme Court has not squarely addressed this textual question, but it stated in Heller that, quote, the people seems to have been a term of art employed in select parts of the Constitution to refer to a class of persons who are part of the national community or who have otherwise developed sufficient connection with this country to be considered part of that community. Then the Second Circuit goes in and basically goes back and forth about whether or not illegal aliens are part of the people textually. And it basically points out that to date, every court of appeals that has heard this case or heard this question has resolved it in favor that illegal aliens are not part of the textual people, which is clearly the correct answer. That's 100% the right answer. But this decision here in the Flores case, they kind of sidestep it a little bit. They basically identify the issues and say, well, we think maybe they're not kind of part of the people, but the reality is the historical tradition is so strong that, guess what? Even if Mr. Flores is part of the people under the text of the Second Amendment and the burden shifts to the government's going to be able to show that those people that are not citizens, that are not loyal to America, they can be disarmed. And that's basically what the court does here. So again, it kind of sidesteps, it discusses whether or not Mr. Flores as an illegal alien is part of the people, and never really answers the question, but indicates he probably is not part of the people, but they don't officially answer it because there was some kind of weird precedent already on the books in the Seventh Circuit that this court kind of wanted to dodge. So they don't address the question whether or not he's part of the people, but they say it doesn't matter for their decision, which is that under the Second Amendment, illegal aliens can indeed be disarmed and forbidden from possessing firearms in the United States, consistent with the Second Amendment. Now, the Seventh Circuit goes on and explains the historical tradition of restricting gun ownership, arms ownership here in the United States with those individuals who are not loyal to America. They go back, this court goes actually back to England and talks about the English Declaration of Rights in the late 1600s, after William and Mary come to the throne as the new kings, if you will, the king and queen of England. Now, in that context, they point out that the English Declaration of Rights, or the English Bill of Rights, specifically says that Protestants have, and this is carefully, folks, because this is important, Protestants have a right to keep and bear arms. The reason why they don't say Catholics at the time is because there was a perception, rightly or wrongly, in the late 1600s in England that Catholics in England really had already sworn an allegiance to the Pope. And the Pope was viewed, and technically it's true, the Pope is the head of a government. The Pope is the head of the country, of the Vatican, Vatican City, the Catholic world, and whatnot. So basically, in the English Declaration of Rights, the reason why they only said that Protestants have the right to keep arms in England is because they viewed the Catholics in England as beholden to and pledging their allegiance to a foreign power in the form of the Catholic Church and the Pope. Again, that is the precedent. Remember, I always talked to you about how bricks and bricks and bricks give rise to precedents and give rise to decisions. Well, here's an example today in this Flores case by the Seventh Circuit where they point this out. And they say the reason why, again, the Catholics did not have the right to keep and bear arms in England in the late 17th century was because they were loyal to another country, the Pope. Now, that gets transported to the United States in a sense, and this court then talks about the history of preventing the slaves who were viewed as not Americans from not being able to have guns. They talk about how the Indians in the 18th century at the time of the founding were also able to be denied the right to keep and bear arms because at the time the Indians were viewed as members of Indian tribes. And those tribes in the United States, what became the United States at least, those tribes were viewed as foreign nations. They weren't considered Americans. They weren't considered the colonists, which is why you see that reference, for example, in the Declaration of Independence in 1776 that refers to the merciless Indian savages. Again, they are viewed as not loyal to America, not loyal to the colonies. They were viewed as a tribe or as a separate country, beholden to a foreign power, i.e. to their tribes and not to the colonists. Then this court goes on and talks also about the fact that at the time of the American Revolution, those people who swore an oath to the patriot cause were allowed to keep and bear arms. But those individuals during the American Revolution that refused to swear an oath to the American cause, to the patriot cause, and instead basically were the Tories, they were the ones that were still loyal to King George III, the English king, those people could be disarmed. In fact, in many of the colonies, as I understand it, according to this discussion, even if you refuse to pledge one way or the other, like let's say the Quakers in Pennsylvania, they could be disarmed as well, because if you did not affirmatively swear an oath to the patriot cause, to the American cause, you could be disarmed as not being loyal. But what's interesting is if you later on swore an oath to the patriot cause, to the American cause, you could got your rights restored, meaning your right to keep and bear arms restored during the American Revolution. So this and other examples of a historical tradition of the American experience, starting in England, coming over to the colonies through the Revolution, the experience of Americans having regulations and rules that says that you can disarm and deny gun rights, if you will, to the Indians, to the slaves, to the Catholics in England. All these things form a historical tradition of a principle of regulation, which is that if there's individuals in the United States or in America who were not loyal to the country, they could be disarmed. And by extension, the Seventh Circuit in this decision says that illegal aliens are by definition beholden to a foreign power. They're not here in the United States, so they're not loyal because they're not following the law. And of course, they're loyal to a foreign power because they're actually foreigners. And as a consequence, they can be disarmed consistent with the Second Amendment because that historical tradition of firearms regulation gives rise to the principle that you can disarm people that are not loyal and haven't pledged an allegiance to the United States of America. The unfortunate practice of disarming slaves and Native Americans survived the Revolutionary War, confirming the founders adhered to the tradition of barring groups deemed outside the polity from keeping arms. From the colonies to, most critically, the early republic, governments consistently conditioned the ability to possess firearms on one's loyalty to the sovereign. People outside of the polity were regularly disarmed unless and until they swore an oath of allegiance. This provides strong historical evidence that the founders would have considered such regulations compatible with the Second Amendment. And having found that history, of course, the Seventh Circuit says you can disarm Mr. Flores and you can convict him of violating federal gun control law for being an illegal alien in possession of a firearm today in the 21st century. Here's how the court concludes in the Flores case. The Second Amendment secures for the people a fundamental right. The government thus bears the substantial burden of proving that a law limiting the right fits within our nation's regulatory tradition. That burden has been carried here. The district court's decision to dismiss the indictment against Mr. Flores is reversed, and the case is remanded for proceedings consistent with this court's opinion. So there you have it, folks. That's all for today's episode. Make sure you follow me on X at 4boxesdown. Don't forget to subscribe both to YouTube and to Rumble. And thanks again for all your support here at the 4 Boxes Diner. And I do look forward to talking to all of you again very, very soon here. You guessed it, at the 4 Boxes Diner.
Orders up. Table 2A.